Good morning, everyone, and welcome to the Green, Broilette, and Wheeler Method for Success webinar program on the Federal Express collision cases. While this case is one of the most tragic cases that I've ever worked on, it did present a lot of unique challenges and obstacles that we had to deal with and overcome, which resulted in a confidential settlement for all the victims of this horrific tragedy. I think a lot of you probably already know about this case as it was widely publicized in the media. But we'll tell you a little bit about an overview of the case and the facts in a little bit. But first of all, if you're unfamiliar with our Method for Success program, this is a seminar at Green Roulette where we present unique, interesting, and challenging cases that we've had and give tips and tricks on how to overcome those challenges and how to use tips and tricks that we've used in the past to help you in your own practice. And we also try to make the program as interactive as we can with everything going on. So if you see on the right side of your screen, there's a program where you can actually submit questions to us. So Chris, myself, and Arash, we're going to be presenting for about an hour and a half today, but we'll try to reserve some time at the end for questions. So if you have a question throughout the program that you'd like one of us to answer, please type it in the little box there and post it, and I'll be able to read that off at the end. So with that, let me just give you a little brief introduction for each of our presenters. First, my name is Christian Nickerson. I'm an associate at Green, Broilette, and Wheeler, and I'll be acting in a moderator role today, but I did work on this case with Chris and Arash and others, helped out with depositions, discovery, motions, but the real stars of the show are Chris and Arash, who I think most of you know and will be the primary presenters today. First of all, let's talk about Chris for a little bit. She's a partner at Green, Broilette, and Wheeler. Honestly, one of my heroes. She's a trailblazer and has been a tremendous mentor and friend to me over the years. You can say so much about her. She's won multi-million-dollar verdicts, numerous multi-million-dollar verdicts, and has won just about every award in the book, including the first woman to win Callis Trial Lawyer of the Year. Then we have Arash of the Hamanpour Law Firm, who I think most of you know as well. There's so many great things to say about Arash, but I think what I love most about Arash is his positive energy and enthusiasm for his cases. This is a guy that cares deeply about his clients, and his enthusiasm is infectious. And like Chris, he's won multi-million-dollar verdicts over and over again, as well as just about every honor in the book. So this is a coordinated proceeding, which I'll talk about in a little bit. It was really Chris and Arash who were captaining the ship, along with Jeff Wells of Green, Broilette, and Wheeler, Paul Kiesel, and Mariana McConnell of the Kiesel Law Firm. And needless to say, we had a great team on this case, which I think was a big part of our success. So let me talk a little bit about this case, just to provide a brief overview before Chris and Arash get into the details. On April 10th, 2014, Timothy Paul Evans was driving a Federal Express tractor trailer on I-5 near Orland, California. He was operating the vehicle in the southbound lane, and traveling in the northbound lane at the same time was a group of high school students and chaperones. These kids were from Southern California. They were they were going to be the first generation of college students from their families to attend college, and they were going on a tour of Humboldt State University. So as they're traveling northbound on I-5 and Evans is traveling southbound in the FedEx truck, he activates his left-hand turn signal and then crosses over the median on I-5 and entered into the northbound lanes. And he hit the bus head-on, which resulted in a tragic and fiery collision with the bus full of kids. 45 passengers were on board, and 8 lost their lives from this tragedy. So obviously, when a tragedy like this happens, of this magnitude, with so many plaintiffs, what do? How do you get all of these cases together under one roof in a fashion that makes sense and is efficient? And what we did in this case was we were able to get all the cases in front of Judge Wiley in LA Superior Court through what's called a JCCP. So you may ask, what is a JCCP? Well, it's a judicial coordinated proceeding, and this is a special procedure where you can have all of cases under one roof. It's not a class action, but it kind of operates in somewhat of a similar fashion, at least getting all the cases together. So you're in one courtroom with one judge who's going to all make rulings for each of the cases. So what we did, one of the first things that we did in this case was file a petition for coordination pursuant to Ccp 404. So that's something that you might want to look up and take a look at. And we submitted it to the Judicial Council, the chairperson of the Judicial Council, who agreed with us that these cases should all be coordinated in one courtroom. And Ccp 404 sets forth a lot of the factors that the judge and the court has to look at to determine whether coordination is proper. And honestly, this case was primed for coordination. All the factors ruled in our favor. At the time we filed the petition, there were 4 cases in LA Superior Court and 1 case that had been filed up north. And all the kids, as I mentioned, all the victims, they were from Southern California. So for the convenience of the parties, it really made sense to have the case venued here in LA, which we were successful in doing. So with that, Chris may want to elaborate on that a little bit more, but with that brief introduction, I'll turn it over to Chris and Arash.
Thanks, Chris. Jess, could you change slides? And really, this is the immediate aftermath of this collision. And one of the key challenges that we faced from the very beginning when this crash happened, it was a huge event. The 5 freeway was shut down for almost a day while investigators came in to investigate the cause of the crash. And there were really dozens, if not hundreds of investigators who came out to the scene. And from the very beginning, we had to wait almost a year, wasn't it, Arash, before we were able to get the concluding reports, the investigative reports that became the task we had to establish what really happened in this crash. Was focused on how do we attack what happens, what the conclusions were in the NTSB report in particular. The NTSB is the National Transportation Safety Board, and the CHP sent in their, what they call the MATE team, the Multi-Accident Investigation Team. And these are their very, very highly trained and very experienced investigating officers, including experts in accident reconstruction, experts in distracted driving, experts in behavioral science. This scene was the subject of a year-long investigation. And if you go to the next slide, we got this report from the National Transportation Safety Board almost a year after the crash. And immediately we had our challenges in front of us because the NTSB concluded on the next page that the cause of this, the probable cause of this crash was the inability of the FedEx truck driver to maintain control of the vehicle due to his unresponsiveness for reasons that could not be established from reliable evidence. So this is the NTSB, and we're going to look at a couple of more of their specific conclusions and then talk about how we approached undermining or at least exposing the faults of this conclusion. Go to the next slide. So what we had was one of the facts that the NTSB relied on in deciding that the driver was unresponsive when he crossed over the road was that they didn't see any signs of braking or other evidence that the driver was doing something to avoid crossing the median and going into the opposite lanes of travel. And on the next slide, they also decided that the driver was not using his cell phone at the time of the crash. And there was no suggestion, according to the NTSB, that there was any driver distraction. So faced with those conclusions, we had our team start to look at how do we determine if this is true, and why it was so important to explain an alternative reason for this crossover. And Arash, why don't you talk? Let's go to the next slide.
Well, the first thing everyone has to understand is saying that the driver's conduct, that he was unresponsive for unknown reasons, means a slam dunk, no case for plaintiffs and defense for Fedex. It's the sudden medical emergency defense. If you're driving along in your car and you have a heart attack and you run over somebody and you had no reason to believe that you would have a heart attack, it just came out of nowhere, the law forgives you because you're not engaging in unreasonable conduct. So here you have the federal government and the CHP essentially concluding this driver did nothing wrong. They researched everything, looked at his medical records, had the autopsy done. They could not establish that he had some reason to believe that he would cross over, or they evaluated all his cell phone records and the cell phone, et cetera, and found out that he wasn't distracted for that reason or any other reason. So you're starting with no case. It's not just like looking for something. It's like you've got a huge burden to overcome. And so this graphic is just important because it happens in all of our cases. I love the CHP, I love investigators, but they're all human beings and they make mistakes. And so picture a football field with 700 wide receivers waiting to catch a punt, and they all drop it. And that's literally what happened. Two critical things were missed, which we're going to cover today. Two minor critical things that transformed this case. Number one was a one-line entry in a cell phone record that no one got, a data exchange. And number two, which Chris found and really transformed the reconstruction and showed purposeful movement, were tire lines in the ground that no one caught and attributed to the reconstruction. And with that excitement, hopefully that's exciting, I'll give it back to Chris.
Well, and let's just say, to put this in context, whenever CHP and the NTSB investigators in all of the kinds of cases that I do involving a lot of crashes on highways, product liability, vehicle defect issues, many times we're faced with CHP officers or investigators who have a sort of a bias against the drivers of vehicles and tend to overlook things or come to opinions and conclusions that you're confronted with in all of these cases. And so one of the things we started out with was we have a report. We have two reports. The NTSB report was several thousands of pages of analysis of the scene, the highway design, driver distraction, the vehicle condition, thousands of pages. And within them were multiple conclusions and opinions about that evidence. Same thing with the CHP MATE team. They had hundreds of interviews with witnesses, which had been recorded. They summarized all of these things in these reports. And so the starting point for me is to look at the granular detail of what the conclusions are based on. And many times the law is pretty favorable for us, particularly with the NTSB and the MATE team, in terms of excluding opinions and conclusions of the investigators. But they're many times allowed to give testimony about their own observations, what they saw, what they heard, what they documented at the scene. So granularly, we started going through the detail from which the big conclusion was based. And I really think that is, when you're faced with a report like this, that literally says you have no case, you have to figure out if there's something there that was overlooked or misinterpreted to get to the conclusion, and then work your way from there to hopefully exclude the opinion.
Well,
so let's go to
there's no substitute for you looking through every single page and challenging everything written, because it's your job as a plaintiff's attorney is to get justice. And if something doesn't smell or look right, you just need to spend the time and the effort to do this. And Chris is one of the most well-known trial attorneys in the country, and yet she'll tell you she sat and went through line by line. She didn't delegate it to an associate. This is what she loves to do. And Chris, isn't it true that when you love what you do, the truth finds a way to you? This is so weird. This happens all the time in your cases, is you'll find that one thing everyone overlooked, don't you?
And there's no doubt. There's been time after time where the nugget comes to you. The piece of information is right there. And if you spend the time digging and looking and questioning, they might have been right. They turned out to be wrong. They might have been right. And if they were right, we didn't have a case. And I'm not going to take my clients through an exercise to go to a trial when we're wrong. So you have to know when there's something wrong or when they're right, because otherwise you cannot properly advise your clients. But I'm skeptical. I'm skeptical because there's enough times where I have seen officers who are well-meaning and want to get the answer right. They've missed something important. And that's what happened here. As Arash said, 2 places where the key evidence was missed. They had it, but they overlooked it, or they rejected it, or came to conclusions that it didn't mean what we believe it means. And when Ara says, okay, the accident scene, that was my sort of baby. Arash was the phone records. And so we've kind of split this up into talking first about the accident reconstruction and why the conclusion that this driver didn't just die or go unconscious before he started crossing into the opposite lanes was a wrong conclusion. And Arash gave us the alternative explanation for why this happened through a very, very, very hotly contested battle over the cell phone records. So let's go to the next slide.
That just was a never give up slide for everyone who was watching.
Go back
never
to
ever give up. You can get out of any situation.
Never give up. Okay, love it. So let's go into the detail. What really happened? Was this sudden death? This was Fedex's conclusion from the beginning, was that this driver died before he crossed the road, and that there was no evidence that he was doing anything to move or drive the tractor after he started into the median. We believed it was cell phone use. And let's go into some of the detail of why we came to that conclusion. This is the photograph of Timothy Evans. He was the driver, and this is his wife, Candace. He was 32 years old. He had 2 children. He had been a FedEx driver since 2011. He had driven in city driving for the couple of first years, and then he became a road driver where he was doing, in this case, he was doing what's called a turnaround. He was driving, he was based in Sacramento. He would drive north to the Oregon border and meet another driver coming from the opposite direction, and they would do what's called a meet and turn. They would change trailers. So the other driver would take Evans' trailers back north, and Evans would come back with the empty trailers back to Sacramento. So this was a round trip. And we had evidence concerning where Mr. Evans had been and what he had done the day of through testimony that was taken from his meet and turn driver. Let's go to the next slide. And this is the scene of the highway. And I would just want to orient you. If you look to the right side, empty lanes, those are the southbound lanes, and the green sign on the right is approximately where Evans starts to cross into the northbound lanes. On the left side of the frame, you can see the remnants of the bus and the remnants of the tractor trailer in the position they were in at the end of the collision. So looking at that orientation, let's go to the next slide. What was the basis of the medical emergency defense? First of all, the law is really important to understand. This is a very, very hotly contested issue in trucking cases these days. It's coming up a lot. And California, there are some older cases that lay out what the defense has to prove. This is their burden of proof. In order to obtain this defense, the defense has to prove 3 things. that a medical condition or illness was the cause of the loss of control of the truck. And we said they had to prove the cause of the medical condition or illness and that it was unanticipated by Evans. So for example, if someone is a diabetic and they're not well under control and they occasionally have pass out because their blood sugar level is not under control, that's not an unanticipated medical condition. That's something that a driver knowingly is operating a vehicle when they in fact might pass out. So they, if that were the circumstance, then this defense, they would not be able to meet their burden of proof. The older cases that we talked about with Judge Wiley had examples of someone sneezing and having a crash because they would sneeze. Now that was a really old case. There were some other ones having to do with heart conditions or things that, you know, had not previously been revealed to the driver. And Arash, do you want to add anything more to that?
Well, no, I mean, here, the guy was healthy. You're going to talk about it, but there was no medical or condition or illness before or even for us during. And one of the big debates was with the judge, what's the legal standard? What's the evidence? And how much is enough for an inference for Fedex to go forward? And just a side note, one thing we debated but ultimately did to flesh out the facts that supported this defense and get the issue before the judge so he understood it, not a week before trials and deciding it on the fly motions in limine, is we did a motion for summary adjudication of this affirmative defense using their factually deficient discovery responses to meet our burden to show they couldn't meet it. And this allowed us to see exactly what they were arguing, their expert testimony, well in advance of trial, and then let the judge get his hands around the proper legal definition. We didn't ultimately win on knocking it out, but we did win on getting everything out in the open so our experts could react to their nonsense ultimately.
Right, and that strategy was one that you had suggested, and I know you've used successfully before. I don't think I've ever done a plaintiff motion for summary adjudication before this case, and it really was a key turning point in the case because we had gotten the defendant's discovery responses to form interrogatory 15.1 and 16.1. What do you claim the facts are that what are your basis of your affirmative defenses? And they were very, they said, oh, we're relying on the NTSB report and the CHP report. Well, that wasn't enough. And they knew it. So when they filed their opposition to the summary judgment, they included declarations from two experts, Judy Melnick, who was their pathologist medical expert, and their accident reconstruction expert. And Judy Melnick said, okay, these are the medical reasons why I believe he was unresponsive. And the reconstructionist said, oh, I believe that he didn't steer or do anything responsive once he's in the median based on the physical evidence. So we then picked those apart. And really, in our response, we were able to take their depositions and get them more detail. So let's look at some of the detail a little bit more. So the things that were really critical to the defense position were, first of all, Whitman, he was the meet and turn driver. The meet and turn driver said that when he and Timothy Evans traded trailers in the parking lot of a McDonald's at about 2 o'clock in the afternoon, that Evans looked clammy and sweaty. So apparently that meant he wasn't feeling well. He didn't say he wasn't feeling well. We actually had video from his encounter inside the McDonald's ordering a drink, a soda of some kind. And there was video of him. Really grainy, not great video. But that testimony, according to the defense, was, well, maybe something was wrong with him. Maybe he was not feeling well. On the other hand, we thought, well, if he's 2 hours earlier in the parking lot of McDonald's and he's not feeling well, then it's not an unanticipated medical emergency. It kind of worked maybe both ways. Ben Lopez was one of the students on the bus. He was a few rows behind the driver on the left side. And Ben Lopez gave a statement to the NTSB, which we'll look at in more detail. He gave a statement to the NTSB that suggested, after he was questioned, that perhaps he saw the driver slumped over and unresponsive in the truck before the collision. That was a very significant one, again, that we had to pick apart. The third was the path of the vehicle. And as we said, really the NTSB and the CHP concluded that this driver drifted to the left, that there was no steering or braking after he turned on his turn signal and the vehicle started to go to the left. And therefore, given how long it would have taken from where they believed that drift started, it was too long for a person who was conscious not to do something when you're about to go into the oncoming traffic and clearly be in jeopardy of having a crash. It was something like 8 to 10 seconds. Their conclusion, the NTSB and CHP, was that he had that much time. And we all know generally from accident reconstruction that normal perception reaction time is 1.5 to 2 seconds. So if something's happening and you're not reacting, then there must be some reason you're not reacting that you can't react. That's the conclusion that was the basis for the report. And then the autopsy findings, which we'll talk again about more as well. Mr. Evans, there obviously was a huge fire, and the people who died in the fire. And Mr. Evans had 3 things that Judy Melanik, the defense expert, said supported her opinion that there must have been a medical condition that incapacitated Evans or killed him before the crash. One was that he had a liver laceration. And according to them, there was minimal blood in the cavity where that laceration occurred. And therefore, he must have had low or no blood pressure, because he would have had seconds to bleed out if he were alive. He would have had more blood in that cavity. The second was that his carboxyhemoglobin, so this is when you intake carbon monoxide from a fire or when you smoke, your carboxyhemoglobin level goes up. And it's typically not fatal until it gets into the above 30% range. And Mr. Evans was less than 3%. And so he also had minimal soot in his trachea on his autopsy, and they did a second autopsy. And the reason that that was supportive of their opinion, their expert's opinion, was if you're not going to have carboxyhemoglobin in your blood, you're not going to have soot in your trachea if you're not breathing. And if you're in a fire and you're not breathing, then according to them, it means you're already dead. And so our alternative explanation was based on not just Mr. Evans' condition, but also the condition of the other bus passengers, which we'll talk about a little bit further down.
So Chris, just it's important. There's no, we lose, they win. This is powerful, right, supportive testimony detailed on sudden medical emergency that any judge looking at this goes, yeah, plaintiffs lose, there's no case. That we wouldn't have known these details until after the discovery cutoff, until after we had deposed their expert, and we'd be scrambling to react to these pretty complicated factual issues with no discovery rights. And so this is why you have to do the motion for summary adjudication well beforehand, because we had a lot of time to challenge these assumptions.
Right. So let's go to the next slide. This is the clip from Mr. Lopez's statement. And the reason we included this is this was actually recorded, and this is a transcript from the officer's inquiry of Mr. Lopez, the bus passenger. And what you can see here is the officer is actually giving a leading question to Mr. Lopez, from which he didn't volunteer that he saw Mr. Evans slump towards the door. The officer suggested it to him. And one of the really interesting developments was the defense expert, Mr. Fenton, who had done a visibility study. Mr. Fenton had gone out and taken the bus and the truck that you saw on our first slide, the exemplars, and he positioned them in a parking lot, and he sat in Mr. Lopez's seat, and he took photographs to document what Mr. Lopez could have seen as the truck was crossing the median. And he did it from 3 locations. So the truck in the median before it comes across into the opposite lane of travel, about 100 feet or so closer, and then just before impact. And at Mr. Fenton's deposition, he acknowledged that in his 3 locations, the only time he could see the driver from Ben Lopez's position was when the truck was about to hit the bus, literally just before the collision. So that was pretty critical, we thought, in helping to put in context Mr. Lopez's testimony.
Well, and the important thing is, they weren't expecting you to figure out that you're going to use their seating chart of visibility against them on this one issue of what did one student see. But that's why you need to know your case inside and out, and you're taking a deposition of an accident reconstructionist and thinking, how can I use anything he's done against them on this other collateral but important issue of what did one of the students see, and could he see what he saw after an officer suggested the answer to them? Go ahead.
Right, and in questioning experts and taking their depositions, I don't know about you, Arash, but that's what I'm looking for. I'm looking for getting them to agree with me on key points, and also finding the places where there's something in their file that hurts their case. And they gave us several opportunities here, and we're going to talk about a few more. But let's go to the next slide, because now let's talk about the path of the vehicle. This is the diagram that the CHP MATE team put together. And I have circled here what we call tire marks 1 and 2. They called them tire marks 1 and 2. These were the marks that the officers concluded showed where the vehicle entered the median. And they were wrong. Why were they wrong? Let's go to the next slide. I've showed this a little more close up because what I want you to observe here is that it's a very straight path. And you can see how if these are in fact the tire marks of this tractor trailer crossing into the median, they're straight. And there's not a lot of movement. There's no turning apparent in those marks. And it really does look like if you're following that path, it's a drift. It's not a sharp swerve that indicates some type of steering. So let's go to the next slide. Why is it that they missed what we're going to show you are the actual tire marks? This is when the scene diagram was prepared, or when the measurements were taken, when the evidence at the scene was documented. It was after 10 o'clock at night. Now this crash you saw happen in the daylight at 5:40 p.m. It was still light out. But the teams of experts from the NTSB and the CHP who were going to document this scene didn't get there until it was dark. So they were using flashlights, and they were using, if you go to the next slide, these balloon lights that they brought in to illuminate the scene. Tire marks 1 and 2, we found out from deposing the people who did the diagram, were identified the next morning at 7 or 8 in the morning. As one of the sergeants was walking the scene, he walked back upstream and said, you know what, I see some marks here. Let's mark them and survey them and then decide what we've got later. So tire marks 1 and 2 were the very, very last pieces of evidence that the CHP team located and then used in their diagram. What did they miss? Let's go to the next slide. As I pointed out in that overhead slide, on the right, you see the green sign. So this is Mr. Evans going south. He's just before that sign, he's crossing the median. This is a MATE picture that was taken by an officer who got to the scene while it was still daylight. You can see the kids on the side of the road on the right. People were still there. It was still light. And this officer started taking photographs because he thought, I'm going to document the scene while there's still light. Unfortunately, his photographs were not either reviewed or transmitted in such a way that the team putting together the survey and the reconstruction diagram saw and relied on. But I saw this picture and I thought, that sure looks like a tire mark to me. And there's a police officer standing right there on the center line. And I'm looking at that saying, sure looks like a tire mark. Let's go to the next slide. And
everyone needs to understand, why are we talking about tire marks? I just want to make everyone understand. If you find a different set of tire marks, that changes the trajectory of the truck, and that changes your assumptions about, did he drift over or did he purposefully get over? And so this discovery transforms the reconstruction in a way the defense had no idea you were going to do this, but you saw it, held on to it, set the deposition, set the stage, and go ahead.
And what you can actually see here is the to the left of the circle are the dual rear wheel tire marks from the left side of the tractor trailer, and above that, further to the south, closer to the trailer, is the second set of dual wheels from the right side of the trailer. This is and measurements support, when you do photogrammetry, you can measure these tire marks. That's the width of a trailer. And so this is where it looked like this tractor trailer had actually gone off the road. And so we found, Marianne, I have to say, found this officer who was now retired who had taken these photographs. So we went up to take his deposition, and we asked him, why did you take these pictures? And he said, well, I was just trying to document the scene. Well, why did you photograph these marks? Because it looked to me, I used to drive a tractor trailer, looked to me like that's where the tractor trailer crossed into the median. So I took those pictures. And, you know, the lawyer who was there for Fedex tried his best to undermine that conclusion. And it was truly one of the highlights of the case. He asked this question, you know he was going to ask. He said, well, isn't it possible that those marks are from another vehicle that crossed the median at another time and are not associated with this tractor trailer? And the police officer said, nope, that's not possible. These are the tire marks where it crossed the road. And so we then get to the officer who was responsible for preparing the scene diagram. Showed him his diagram with tire marks 1 and 2, showed him this picture and said, do you think you got it wrong? And he agreed that tire marks 1 and 2 on the CHP mate diagram were not the path of the vehicle. That instead, the path of the vehicle was based upon these tire marks. So let's go to the next slide.
Just wait, people have to understand, getting a CHP officer or 2 officers to admit a mistake was made, something was overlooked, that transforms a reconstruction that's been published for over a year and relied on everybody, is a delicate task. But it can be done if you're just, I mean, again, you know, the attorneys show up and they're hot and they're angry and they're aggressive and they think they intimidate people and blah, blah, blah. You know, this is where you get more with sugar than you do with poison, and just being kind and setting the stage that, look, a mistake was made, and Chris got that key acknowledgement that transformed the reconstruction. Sorry, go ahead.
So, you know, I'm not often accused of being kind and soft, but there are times where you want to gently get someone to agree that, you know, yeah, that looks pretty compelling to me. Those marks look pretty darn like a tractor trailer's dual rear wheels. And then when the accident reconstructionist could actually measure them, and they can, it it was conclusive to the point where the defense had to agree that these were in fact the correct tire marks. And what I show on this slide, this is from our reconstruction expert. The yellow lines are the ones in the photograph you saw. The green lines are the paint marks from the CHP marking tire marks 1 and 2. You can see that it's a very different path. One being the drift, the other being a swerve. And ultimately, if you go to the next slide, we also have the yellow tire marks would be the path of the vehicle based on the initial entry into the median. And then the next slide is really after a very, very long battle with experts. This is the second vehicle handling expert's testimony. And let me just give a little more background about this. The key defense position from the reconstruction is that there is no active steering or braking when the vehicle enters the median or crosses through. And the first expert, Mr. Fenton, used a computer simulation to model the vehicle crossing into the median. And his conclusion was no steering in the median. Our expert took his simulation and got the input data for that simulation, critical. Because when our expert looked at that data, he said, you know, in order to keep the path of the vehicle to hit the bus in the simulation, they have input steering in the median. And I'm thinking, you gotta be kidding me. They're telling there's no steering, but their computer path has steering. How is that possible? So they had to answer that. They had to come up with an explanation. So what they did was they said, well, we used the default data, the default settings for a tractor trailer, stiffness of steering, among other things. So we're going to redo it. We're going to redo our simulation to take out any steering. And in order to do that, they had to go spend gazobs of money to do testing and how stiff a steering is. And they came up with a ridiculously high stiffness that was pretty much not gonna, it's not reality. But you know, they had the expert who said it was. And so this is that expert who comes in and says, oh, forget the simulation. There's no steering. There's no steering in the median. But what he had to do was concede that the driver steered to get into the median. There was consciously steering to the left. This was not a drift. And that was their whole basis for their timing and how he must have been unresponsive. So this was really a very critical ultimate conclusion that he gave us steering.
One critical thing. So again, everyone understand, they fought to get the defense experts' files on some esoteric software used by a handful of people in the country to do specific stuff. They never give it to you. They don't want to give it to you. They claim copyright. They say, oh, you don't need it. Oh, we don't have the files or blah, blah, blah. And literally getting that file on software you can't even open, but your expert can, if your expert's aggressive enough. And if they don't have the file, go buy the software. You find that they put an input of steering that's totally inconsistent with their reconstruction. That small little detail of probably 1,000 inputs is what transformed and gets you this perfect quote to use at trial.
So let's go just a couple more slides on the path of the vehicle. This just shows you the difference in the curvature. The orange is the original and the yellow is, or the right side is ours. And this is comparing the two reconstructions. Ponderosa was our experts, Kineticorp was theirs. Let's go to the next slide. And you can see if there's no, this was fascinating to me, and it may have been too detailed. Sometimes I'm accused of that, but this is our experts comparison. If you have no steering in the median, none, then the tractor trailer goes straight. It misses the car. First of all, before it hit the bus, it hit a car, which is, you can see on the left, that's our reconstruction with steering. if the tractor trailer has no steering at all, it misses the car and it misses the bus. So they kind of can't get where they want to get at the end. And that's the thing with reconstruction. You're working backwards. How do you get from the end point working upstream? What has to happen? They can't get there to the end point using the no steering conclusion.
Well, it's very simple, Chris. I'm going to give you I'm not as well versed on reconstruction as you, and you handle much more complicated cases, but it's very simple. You ask your expert. Mr. Caldwell, one way you test out your reconstruction is to do a simulation where you put the inputted assumed values and you see, does it follow the path of what we see? And does this tell FedEx and its experts their assumption that there's no steering is absolutely wrong? Does this tell them before they come in this courtroom to tell you what their opinions are? Does this tell everyone on their side their assumptions of no steering is wrong? Yes. Why? Because their reconstruction shows it goes and misses the bus. Hey, did this miss the bus? No. That simple. When you show that they play around with assumptions, you show that they're lying and misrepresenting the reality of what is probably one of the most horrific crashes these jurors are ever going to hear. FedEx is spending money to try and, snatch justice away from these deserving families. Go ahead. Sorry.
That's all right. Let's just talk briefly about the next key issue, and this was the autopsy findings, and then we're going to spend some time really talking about the cell phone records. So just briefly on the autopsy findings. Remember, we had the liver laceration with the little or minimal blood. We had the carboxyhemoglobin percentage, which was negligible, and we had minimal soot in Mr. Evans' trachea. So how did we approach that? Let's go to the next slide. Really, we didn't contest those findings. And by the way, the autopsy of Mr. Evans and the bus passengers were all done by the same medical examiner, not a hired expert up in Northern California. Now, I did say that the defense also had their own autopsy done separately, and there were actually 2 pathologists in that autopsy. But we did not have evidence to dispute the carboxyhemoglobin levels or the soot or the bleeding. But we did have the very, very, very terrible but very consistent findings on the bus passengers. And the key was that the people who were in the front of the bus, set aside the bus driver was crushed. There's no question that crash forces were led to her demise. But the other passengers in the front who died, several of whom were ejected, none of them had significant carboxyhemoglobin. None of them had a lot of soot in their tracheas. So again, if the conclusion is that you have to be dead in order to have no carboxyhemoglobin and no soot in your trachea when you're in the middle of this horrific fire, then the conclusion can't be that all these people were dead too before this crash occurred. It doesn't make sense. And the defense explanation for why Mr. Evans was deceased, but everyone else wasn't, is that this fire was not a superheated, intense explosion of superheated gases, that instead it was a diesel fuel fire that slowly grew into a bigger conflagration, and therefore Mr. Evans would have not, who would have been in his vehicle, would have had an opportunity to breathe in, and that's why he must have been deceased before the collision. We brought in a fire expert, again, competing experts. Our expert said you can have a fireball from an explosion of pressurized diesel fuel, and that's what happened here, and the gases were superheated. And in his opinion and the medical opinions, if you were to breathe in superheated gases, your trachea isn't going to stay open. And so this was how we approached the autopsy findings.
But Chris, It's important for everyone to understand what you're seeing on the left side of the screen if you didn't have on the right the bus passenger autopsy finding data, a lot of experts that you'll consult with will say, if you have what's on the left, you know, he was incapacitated before the crash. And so it's just, you know, you really have to challenge even what you see in terms of current science and what current experts will say, and just really be creative. You know, again, I think if you're on the right side of the case and you're on the right side of, you know, justice, these facts find your way to you. Because again, it's just unusual that you have data from other people on the bus who weren't dead before the crash that allows you to undermine what seems like a very powerful defense for the defense.
Okay, so let's talk about the cell phone records. What really happened? Arash, you're going to lead this discussion. This is your baby.
This is crazy. So I was not on any committee. I'm just one of the attorneys. I had 2 plaintiffs, and you know, I just don't trust anybody. I do everything myself. I independently review everything. So we get the records, we get this long report, and I look at the cell phone records and I see, if everyone knows a cell phone bill, there's 3 parts. There's the calls, there's texts, and there's data. And this set of records was only for, I think, the calls and texts. So I call Chris and I'm like, Chris, you guys don't have the full cell phone records. And she's like, what do you mean? She's like, they wouldn't miss something like that. I'm like, Chris, we need to get the full cell phone records. She's like, okay, I trust you. So then we basically, she does, I didn't do it, they do excellent work. They file a motion to get the cell phone records. Of course, they come back with, you don't need the cell phone records. You know, the NTSB reviewed it. There's no driver, what, blah, blah, blah. You're invading her privacy. They ultimately get an order compelling the cell phone records. Then the defense comes back with a motion for reconsideration saying, like, it's not her cell phone records, we can't get them, blah, 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 blah. You know,
we're trying to get them from the wife, by the way. When you say she, wife, we're trying to get from the wife the records that related to her husband's cell phone, which she had. We know she had them.
And a year or more had passed since anyone had even asked for them. No one asked to preserve them because no one thought the cell phone records were important. And then they almost violated an order to compel. And like literally at the last minute, they gave us like a few pages saying, here's all we have. We don't have anything else. And then we had to go and get it from T-Mobile. And lo and behold, let's go to the next slide. There's one entry from the portion of the data part of the cell phone that shows when he was charged or when there was data exchanged. And at 5:38, you have this small data exchange 2 minutes before the crash. So it's not at the time of the crash. There's nothing showing he was on his phone at the time of the crash. But here you have a record showing something's going on with his phone right before the crash. And I'm going to point out something. And so I went, you know, full bore into this issue and trying to figure out what does this mean. And Chris's firm hired a lot of experts to really explore this. But it really just wasn't this one entry. What Chris had done is she had, I remember we're on a phone call talking about a million things about this case. And Chris goes, hey, you need to go through to her office. I want everyone to go through every time he's on his phone to see if he's driving, because FedEx had a policy, you're not allowed to be on your cell phone when driving. And what Chris figured out is this guy is routinely texting, calling, sometimes with other FedEx employees while he's driving in violation of the FedEx policy. Last point. Go ahead.
And how we match them up is with a tractor trailer, a professional driver driving for a company like FedEx. They have GPS tracking of those vehicles. And they had produced to the NTSB and the CHP this log for 3 months of his driving. They were looking for whether he was tired, had fallen asleep, whether his hours of service were, whether there was some pattern that he had perhaps, you know, been overtired. So they have this data. We got the GPS data for 3 months of his driving of a vehicle. Well, then when we got the cell phone records, we got a year's worth of his cell phone records. And so we matched up. It's literally the Excel spreadsheet. Here's the date and time. Was the vehicle moving? Were the wheels turning? Was he on a call at the time the wheels were turning? And I had one of the FedEx dispatch people match I showed them, match him up. Was he driving at this time? Yes, he was. If he's on his cell phone at that time, talking on a call or texting, is he in violation of the policy? Yes, he is. So we had a history. We had 3 months of a history, and there was going to be a huge fight over whether anything other than what happened on the day of the crash was going to be admissible into evidence. So back to you, Arash.
Well, just again, 2 lines in a photograph, and this little line in a cell phone record that wasn't obtained by anybody, that we asked for, that we fought and got, transformed this case from no case to one where, you know, ultimately you're resolved, but where all of this evidence was going to come in front of the jury and look potentially very damaging for Fedex.
So let's go to the next slide. So again, the timing, 5:40 p.m., data usage, 5:38 p.m. The big fight with FedEx was, first of all, we don't have the phone. The phone was burned up. We don't have the computers from home because they broke, apparently. And Candace Evans was rather unhappy when we asked her about these things, to the point where she threw her coffee at me and got up and walked out. And I was really, listen, I feel terrible for Candace Evans. She lost her husband, and she was told by the FedEx people something had happened to him that led her feel better about the ultimate reason this crash happened. She was not happy with the suggestion that her husband caused this crash because he was violating policy and using his phone. So it was very tense. It was very tense, and I'm sympathetic to her. But, you know, we were doing our best to try and explain what kinds of computer apps he used at home. Did he have sports scores? Did he play computer games? Did he watch movies? I mean, there have been cases involving truck drivers where they're watching movies while they're driving. So we had to explain why 2 minutes before still meant that he was distracted and using his phone. So this is where Arash took off. Let's go to the next slide.
And so, you know, Chris's firm hired an expert, and we evaluated what could this amount of data be, and it essentially could be a lot of different things that this driver is doing: sending or receiving email message, using web-based messaging app, viewing a picture on the internet, accessing a website, or using the internet to check the weather, news, or sports score. And the reason getting files or computers or backups or cloud data from the wife was important is it could shed a light on what things he was doing at the time. And of course, that avenue was closed because we're like many years later, and she didn't preserve anything, and that was, we just simply couldn't prove exactly what he was doing. Very important key distinction between direct and circumstantial evidence. Everyone needs to remember, under the law in California, circumstantial evidence is given just as much weight as direct evidence, because sometimes you don't have a confession from the truck driver on video going, I'm distracted by my cell phone. And this shows the power of circumstantial evidence, because all of this is literally just circumstantial evidence of what proved that he was in control and that he was distracted. And so again, this just, you know, never give up the fight for that little piece of evidence. Let's keep going.
Next slide. Yeah.
And so again, the most beautiful part is, I love this, I call this Judah law, is where I take what the defense is doing and use it against him. And I really just, you know, here they hired a very sophisticated team of defense experts from Exponent doing super sophisticated testing to prove we couldn't prove that he was on his phone at the time. And they got a cell phone, went into a tower and into a chamber, created something called Python. I don't even understand what that is. They gave us gobbledygook in terms of like hexadecimal data. I don't know. It was the weirdest stuff ever. And then when you ask them what their opinions were, the experts, they didn't speak in English, and they spoke in like geek code, and then it was like 20 pages of stuff. And I'm not underestimating how complicated this stuff was. But go to the next slide. Their testing basically proved that what they did is they had a cell phone where they separately recorded the data being transmitted on the cell phone through proof. It was like separately recorded. And then they looked at what the cell phone bill recorded. And
So
through
wait a second. They got a cell phone that was equivalent to Evan's, and they opened a billing account with T-Mobile, so that T-Mobile was going to send them a bill after a month.
and went to the same
on his phone.
went to the same tower, the same cell phone tower involved in this incident, and then recorded the data on the phone to see if it matched the data on the bill. And what we showed through one random line of their Python stuff was the amount of data transmitted and received on their phone was greater than what was on the bill. What does that mean? That small number that we had on a cell phone does not necessarily reflect the true nature of his activity, and FedEx's experts proved it. He could have been doing something much more intensive with that cell phone than that small number reflected. That was one thing we proved. Go to the next slide. The next thing we proved is that the guy was on YouTube watching a video on YouTube, and yet the cell phone bill reflected that activity stopped earlier than he was doing the activity. So if at 5:38 there's a charge, that doesn't mean that's when you stop using the cell phone. FedEx's exponent proves to the jury you could have a bill charge at 5:38 and still be watching something on YouTube at 5:40. By the way, those two concessions took like 3 depositions, review 1,000. It was crazy how much it took to get these, and how much they fought us, and how their answers would be like, he was coached to say like 40 different things and not concede anything. Go ahead, Chris.
Well, and before you switch slides, really the fight here, what FedEx was trying to make the fight about was this doesn't count. None of this counts unless he's doing this on his phone at exactly when it's crossing the highway. They wanted a conclusion that you have to have the phone in your hand doing something active in order for it to count. And they pretty much proved that you could be using your cell phone while not holding it in your hand. So once you have that, then the question is that distracting? Because a lot of people think you can have your phone over there and you're on hands-free and you're talking, or you've got something playing in the background that you're looking at occasionally, and you're not holding it in your hand. So is that distracting? And that gets us to the next expert.
But just wait. FedEx had a rule designed to prevent this horrible collision. You're not supposed to be on your cell phone, in your hand, watching it, reading it. You can't be driving this, 20-ton truck of death and destruction. Before he ever crossed over, they know if he's distracted, he's going to kill people, right? And here you have a rule that was clearly violated, and FedEx, instead of admitting it and acknowledging it and say, look, we're responsible, let's make up for the ridiculous harm we caused, they hire experts to fight it, and the experts even show that they're not being truthful, and they keep going. So this was really, like a wonderful case to take to trial in terms of how simple it was with the rule that was violated, and how the evidence really supported that this was, a tragedy that should have been prevented. But go ahead.
So the distraction issue was yet again another expert. And they brought in another exponent guy, Mr. Kuzel. Let's go to the next slide.
And Chris, just before we get there, I'm just going to hop in and just remind the audience that if you'd like to submit any questions, we've gotten a few so far, but now would be a good time, as we've got about 25 minutes of the presentation left. We'll try to answer as many as we can at the end. Thanks.
Yeah, can I just say something real quick? Power of Google searches. I'm not going to tell you how it helps here. All of us know, Chris, Christian, me, a lot of times we transform a case with a Google search right before the expert depo. And people think like, well, what am I going to get from a Google search and Google? But this will blow your mind what Chris did through a simple Google search on a busy day before a busy expert depo with lots of other expert depos. Go ahead.
Mr. Kuzel, who is the distracted driving expert who did a very elaborate study to prove that you could be doing something on a tablet in your truck. And again, another simulation. They go and they get a tractor trailer cab. It's hooked up to a simulator so that you've got a, you know, like when you see pilots are in a simulator. So they have truck drivers. They get 25 truck drivers and they put them in a seat and they have them go around a track that they're watching on screen. And they have them doing something on a tablet with their hands. And then at some point, the vehicle starts to veer, the computer starts to veer the vehicle, and they want to see what their reaction is. And so, of course, they've got all these, you know, slides and scans showing these drivers and how they respond, and they come to the conclusion, well, all these drivers were able to steer back when the vehicle starts to go to the left. They didn't cross the highway. So that was pretty compelling stuff. But Mr. Kuzel has published and given speeches. And so one of the things, I looked through his CV, and he had a lot of things and presentations he's done, and I thought maybe I could find some of them. And I went on the internet and I looked for Mr. Kuzel, and I found this presentation, this PowerPoint. Cell phone distracted drivers, testing the margins of safety. And you know, this was an interesting debate. When you're in a deposition of an expert and you've got something that maybe is going to hurt them, do you save it for cross at trial, Arash, or do you use it in the depot?
I always use it in the depot. I lock them in. I don't want any surprises. If it's this critical, because you're videotaping your deposition, and if you ask the question and answer correctly, it's coming in whether they call the expert or not, because you've properly given notice that you may use video deposition testimony in lieu of trial testimony. So this, whatever you get out of him, you can play in your opening. You can talk about it whenever you want if you've locked it in, rather than going for the surprise. That's my
rather than taking the chance on surprising them at trial and then for some reason not being able to get it into evidence because they dodged the question, or you aren't able to establish that this is you are the Mr. Kuzel who did this presentation. Is that right? Yes, it is. I recognize it. So this is an authentic copy of a presentation you gave to an audience about cell phone distracted drivers. Yes. Why is it important? Let's go to the next slide. Two of his conclusions in his slides. Relating cell use to risk of collision. So on the left, what is the risk of collision from 0 to 10? Obviously, if it goes up, it's a higher risk than if it's on the lower end. Time before a collision. So he's got a study or studies that he evaluated and created this graph. So the longer from the use you are of the phone, the further in time back, the less risk of a collision. Closer in time, higher risk. So in the right side of this graph, between 1 and 5 minutes using a cell phone prior to a crash, it's more than 4 times greater risk of a collision. So he's making this point, you don't have to be holding the phone in your hand at the exact time of a crash in order to be distracted and have your distraction increase the risk of the crash. Next slide is also from his PowerPoint. It's the general conclusion we all have. It's okay, I'm looking at the road. My eyes are on the road. And he has, looking at is not the same. It's not equivalent to attending to the task you're doing. Our eyes can be looking in one direction and our attention directed to another, i.e., e.g., adjusting the radio while keeping your eyes on the road. Simple tasks can be distracting when you're trying to do 2 things at the same time. You're trying to drive and you're trying to do something else. So this is why this evidence was so critical, and it was a very hotly contested battle. So the last little thing I wanted us to cover, Arash, is kind of where we ended up with in terms of the cell phone use and the NTSB report. These were the key 4 motions. The defense had 2. One was to exclude the phone data usage charge, and their motion in limine number 2 was to exclude the history of cell phone, text phone use. So the pattern of him using the phone on prior occasions. 2 different motions. Our first motion was to exclude the NTSB report and conclusions, and our second was to exclude the MATE team report, the CHP report, the essence of those reports, which was the conclusion that he drifted and he must have been incapacitated before the collision. There was a lot of pieces of each of those reports that was going to be admissible evidence, the photographs, the measurements of the things that were properly measured, the statements of witnesses, and coming back again to the little detail, when a police officer interviews a witness, they don't typically record them. That's changing now. Many officers have body cams and recording devices so that the witnesses' actual statements are being recorded. And the reports are usually a summary. So one of the things we found was we got the audio recordings of the witness statements, and there were things in the witness recordings that were not in the summaries in the report. I recall one key witness, Mr. Reyes, who was driving behind the tractor trailer and saw the turn signal turn on and the vehicle go to the left. He actually said in his recorded statement that he saw the driver steer to make a lane change. That was not in the summary. So again, come back to the foundation for the conclusions and look for the things that may support or not support what's in the report. And that's really where I think we, expose some of the inconsistencies or the inaccuracies. So we brought these 4 motions. So what I've got here is just and these motions are available if people want us to send them copies of the motions or the oppositions, we can make those available to you. So let's look at what happens. Next slide. This is the judge's tentative ruling. This was like 3 days before we were going to pick a jury. It was on a Friday. We were going to pick a jury on a Tuesday. Our motion in limine 1 and 2, the NTSB report and the CHP MATE report, both motions were granted. There's some really good supportive law in both of those motions on the context of admitting these kinds of reports or not. Particularly with the NTSB reports, there's clear federal authority that says they are not to be used in litigation like this. Now, the investigators may be required to give testimony about what they saw and what they documented, but nobody deposed an NTSB person in this case. There was no attempt to authenticate any of the observations in the NTSB report. We spent a lot of time with the CHP people. So we were obviously quite satisfied with the fact that the conclusions of these investigating agencies were not going to be told to the jury. The next slide is defendant's motion in limine having to do with the data usage charge. Court denied it. And the next one is the ruling on the historical use of the cell phone. And as the judge said here, these records tend to show that while driving, Evans was in the habit of bringing his phone with him and leaving it turned on. This fact affects the probability that the 5:38 p.m. data transmission affected Evans' driving. It raises the probability above 0. How much beyond that was for the jury to determine. So that's our. You have anything else you want to add? We've got a few more minutes where we can answer.
First of all, Mariana. So
yeah.
Mariana, I mean, seriously, if someone single-handedly was doing work, flying everywhere, we just can't overlook how important she was at the Kiesel firm to really getting this case to where we were, just getting a lot of work done. And the other thing is that, that deposition of Mr. Lopez, I just want everyone to understand, Officer leads Lopez, a student, after a traumatic event to say someone slumped over. And I just read through the transcript while you were talking, and literally the defense attorney tries to lead Mr. Lopez to say, you saw him slumped over. Chris objects. They start fighting for 4 pages of colloquy and da-da-da. And finally, Lopez says, I actually didn't say I saw him slumped over. I didn't really see it. I saw it maybe for 1 or 2 seconds. It was traumatic. And he would not say he was slumped over. He said, at best I can say is he's leaning to the left, which was consistent with our theory that something happened with his cell phone. He bends down to get it. And then by the time he gets up, it's too late to react and the crash happens. But the beauty is Chris went to that depot of this kid and transformed very damaging testimony of him slumped over to, I didn't really see that. That's not what I told the officer. And at best, he's leaning. At best, he's leaning. So again, just the power of never giving up, understanding the context in which officers do their work, what you can get someone to say, and that was just important.
It was really a wonderful team effort on the part of our whole working group, and Mariana and Paul both, and you and Christian, and just, we had a great team. We spent a lot of time talking about, strategy and what we would do next. And it was all really rewarding to be able to get these cases resolved for these families who were terribly traumatized.
And a very, very, very smart, judge who really wanted to get it right, who really read everything, gave us the time to develop our arguments and the opportunity to, make these key issues so that we could get this case in front of a jury. Because it was clear from the beginning, if we didn't do these little, serendipitous things, we would never have gotten a chance to get in front of a jury. We'd be here at this motion in limine stage with no evidence of cell phone usage, and the cell phone would have been out. And again, that habit thing that Chris developed of him using his phone in violation of the policy consistently, that side angle to the cell phone records that I think a lot of people probably wouldn't even think about, really, really transformed the judge's perception of allowing in the cell phone records globally.
Yeah, I will say that I've had other cases with cell phone records at issue, and you really have to start out with not being forced into limiting your discovery to the day of or the hour of. As you can see, particularly, we were fortunate because the NTSB and the CHP had gotten records beyond just that day. So we knew there was some evidence that we wanted to follow up on. I think in many cases, the judges are inclined, if you had to bring a motion, to say, well, it doesn't matter what they were doing the day before or a week before. Particularly in these professional driving cases, I think you really have to push the envelope on that and hope that you can develop this pattern, because we had other drivers admitting that they were texting while driving with Evans back and forth, or talking on their phones together. But the texting is...
And just a little closing argument for the jury. This is the danger of distracted driving. If you drink and drive once and you get away with it, it's not like your average person's like, okay, now I can get drunk every time because I didn't kill anybody. But when you're using a cell phone and you get away with not hurting anyone, you reinforce this concept that not only can I disengage from the road, but I can read content, take it in, continue to drive, and nothing's going to happen. It reinforces the most dangerous behavior for a guy driving a truck that can easily kill, and which is what happened, is he killed people through this dangerously distracted driving. So we were going to get up in front of the jury and essentially tell them this driving is worse than being drunk, right, Chris? Our experts were going to say that.
There's no doubt. There's no doubt. That is, in fact, what a lot of the cognitive research is now showing, that it can be and is as bad or worse than drunk driving.
And FedEx knew it because he was communicating with their dispatch consistently in violation of their policy. They had the data. to tell them your driver is violating your policy day in and day out multiple times during the day, and they did nothing. Nada. They kept fighting this case till the end.
Till the jurors were in the hall.
Yeah, that's true.
Waiting to be questioned down to the wire. So Christian, are there some questions?
Yeah, we have some really good questions from the audience. First of all, this is our kind of conclusion slide. If you have any questions that we aren't able to get to, or if you want a copy of the motions, feel free to reach out to any of us and shoot us an email, or if you want to, set up a time to talk about some more detail about these issues of the case, we're happy to do that. But we do have some good questions here from the audience, and Chris,
So we got 10 minutes.
Throw them out to you. One question is, what impact did the FedEx driver engaging the left turn signal make on the case? Would that tend to show an intentional swerve into oncoming traffic?
Yeah, I think that the turn signal was important because in combination with the testimony from Mr. Reyes, again, which wasn't in the record, but was in his transcript, was that he saw Mr. Evans making a lane change. And so he actually says he didn't just drift after the turn signal went on, he actually straightened out in the lane and then went left. So it showed consciousness. It was important.
Okay. And another question, which is kind of along the lines of resolution. The question is, what method did you all use to allocate the settlement proceeds among the victims? That's not really how we did it. It wasn't a global settlement. Do you want to talk about kind of how these cases came to resolution?
Well, yeah. Yeah, we really don't want to discuss it other than every case was treated individually. Yes. And not as a global.
That is that. And another question, we talked about the medical emergency defense. Did the defense also raise the seatbelt defense, and how did you deal with that issue?
Oh, yeah. Interestingly, this charter bus had seatbelts. Lots of buses don't. It was pretty much a brand new bus. And we did bring motions for summary adjudication on behalf of some of the occupants on the decedents on whether a seatbelt would have prevented or reduced their likelihood of injury. And they're really, I don't think the defense was really going to go very far on the seatbelts, because for the people who died, they were in the front of the bus. And whether they were ejected or not, there were people on the bus who died who weren't ejected, who died from the fire. So it was something that was in the mix on the discussion over individual cases. And, there were some with physical injuries where the argument was that they would have had reduced injuries, particularly the people in the back of the bus. I would say it was an individual case-by-case discussion for a particular one of the students.
Okay. Thank you for that. And then another question about other defendants in the case. Was the bus company a defendant in the case? Did you keep them in? And if so, was there a strategic reason why?
They were in the case. And to the extent that there was some arguments that the kids should have been wearing seatbelts and that there was some delay in getting off of the bus, there was some evidence that the driver of the bus had not given a safety briefing before the bus. They all gathered at the downtown LA train station, and they got on there were two buses, and they got on the buses. And the driver was supposed to show a video and have a demonstration of the emergency exits. And tell people to wear seatbelts. So that was part of the case. It was not a huge focus of the case, but it was part of the case. And there was no ever any argument that the driver of the bus did anything to cause the collision or should have been able to avoid it. None. We were not blaming the driver.
Okay, just a couple more. We've got about 5 minutes. There are some general questions about how a trial with this many plaintiffs was going to work. Was there a lead case, and how was the case selected, if so?
Very, very good question. Judicial counsel coordinated proceeding, it's kind of like an MDL. And early on in the case, we had discussions with Judge Wiley and the defense about picking what was called a bellwether case, like which plaintiff would be starting. And we were initially going to have one of the wrongful death cases and an injury case at the same time. Things changed depending on events with particular plaintiffs. So ultimately, we got to most of the cases had resolved before we got to the final stage where we were going to be picking the jury. And we had a few cases left from which one of those cases, I think it was Arsh's cases, was going to be the first case. So bellwethers is a whole nother topic for a whole long seminar.
We again have some general questions about how to get copies of the motions for summary adjudication and the motions in limine. Again, our emails are here. Just shoot us an email. We'll be happy to provide copies of that. And we've got a lot of other questions, but for the sake of time, I think I'll just wrap this up.
Okay.
Again, thank you very much for spending your morning with us. We really appreciate the attendance and the participation and the great questions that you have. We're actually going to be having another one of these seminars. We do them bi-weekly. The next seminar is going to be August 20th at 10 a.m. And that is a case involving health club negligence. And Bruce Broylette and Alan Van Gelder of Green, Burlett, and Wheeler, our firm, they're going to be presenting that topic. So we hope you can join us for that. And that's going to be interesting. And again, thank you very much for spending your morning with us. And please reach out to us if you have any questions. Chris and Arash, any concluding remarks?
No.
Yeah, just very quickly, this was one of the most tragic cases I've ever dealt with. When we sat through some of the depositions of some of these kids and the aftermath of what they had to deal with of this fire and surviving and guilt and what they saw, what they smelled, what they smoked, what they inhaled and tasted, it was really tragic. And one of the most beautiful things was I created a lifelong friend with my client. We really connected and bonded, and I was just so impressed with how some of these kids really, got through this horrific event and still, got their life back on track as best as they could, and are fighters and living through what, it's just seriously one of the most horrific, tragic events. And I'm just so grateful that I randomly got involved in this case and got to work with Chris. It was in her firm. It was so much fun because we knew we were on the right side of justice. And it was just a beautiful experience all around. And I still talk to my client all the time.
Yeah, I know that we actually, Jeff Wells had a very solid relationship with one of our clients who went to Sacramento to testify in favor of legislation having to do with bus safety. So there has been some positive, outcomes for people. I do feel that there were, for each of the kids that made a good recovery and got back to school, there were a lot of those kids who were scarred and whose emotional trauma was very devastating. And that was really sad for them because, PTSD is a real thing and people react differently to trauma. And so some of them were more resilient, some of them were not. And really, really terrible outcomes for some of the kids. But
we were able to make a difference for a lot of these kids, and a difference that they otherwise would never have had an opportunity to have is some closure. Some closure and then some resources so that they can at least take care of themselves in the future. It was really beautiful.
And for the families who lost their loved ones. There was, obviously horrific loss. So it was really an honor to work on the case with you, Arash. I'm, just kind of like the Spock mind melt, what do we do now? And Mariana and Paul were really an incredible team. So thank you. Thanks for joining us today.
Yeah, thank you, everyone. Hope to see you in a couple.
Bye, guys.
Bye-bye.